Good morning to the esteemed tribunal. My name is Tirunirakandan Mohandas. I am the counsel representing General Granite and will argue for the legitimacy of the arbitral tribunal in continuing to hear the case. As Mighty is the main respondent to this case and the main contract is between General Granite and Mighty, we shall first analyze the issues at hand in relation to the arbitration between these parties. Point number 1. Law governing the arbitration agreement. The law governing the contract is English law, but the doctrine of separability means that it is possible for an arbitration agreement to be governed by a different law than the governing law of the contract. In the absence of indication to the contrary, an express choice of law governing the substantive contract was a strong indication of an implied choice of same law in relation to the agreement to arbitrate. However, in the case of Sulamerica CIA National de Seguero SA and others versus NSA and Harrier SA and others, the Court of Appeal provided guidelines to determine applicable law of an arbitration by undertaking three-stage inquiry. Applying the same principles to this case, we can make the following correlation. Number 1. Express choice. The arbitration agreement contained no express choice of law. Point number 2. Implied choice. The parties has agreed that the governing law of the substantive contract would be English law. Number 3. Closest and most real connection. Since English law is the law of the contract or substantive law, it provides supporting and supervisory jurisdiction necessary to ensure that the procedure is effective. We shall also analyze the seat of arbitration. Seat of arbitration is not the same place where the arbitration is held. Section 3 of the Arbitration Act states that the seat of arbitration means the judicial seat of the arbitration. Although Article 21 of the contract provides for ad hoc arbitration to be held in Scotland, taking all the circumstances into account and by drawing reference to the case of Brace of Doon Wind Farm versus Alfred McAlpine Business Services in 2008, where Judge Aikenhead decided that even when the seat of arbitration was nominated in Scotland, the reference to seat was intended only as a reference to the place of arbitration. The counsel argues that the actual seat is in England. Therefore, the arbitration shall be governed by Arbitration Act 1996 and the seat is England with sole arbitrator under unscriptural rules to be held in Edinburgh, Scotland. We shall now move on to analyze the legitimacy of the arbitral tribunal continuing to hear the case based on provisions and applicable laws and rules. The mandatory provisions included in Section 4 of Arbitration Act 1996 shall apply and other provisions shall be as per the unscriptural rules. Point number 2. Does an arbitration agreement exist? There is no clear and consistent approach in England to the way in which arbitration agreements are to be interpreted. Since Article 21 of the contract provides for ad hoc arbitration, the English courts will go to considerable lengths to give effect to what they see as an agreement to arbitrate. For example, as determined in the case of Hobbs, Paget & Co. Limited versus J.C. Kirkland Limited in 1969. Point number 4. Notice of arbitration. We shall first analyze the rules applicable to commencement of arbitration. Although Section 14 of the 1996 Act provides relevant rules with regard to the commencement of arbitration, it is a default section, so we shall analyze it as per the unscriptural rules. Paragraph 1, Article 3 of the rules provide that the claimant shall communicate to the respondent a notice of arbitration. This was done by General Granite by issuing an email to Mighty. Paragraph 1, Article 2 of the rules provide that a notice, including a notification, communication, or proposal, may be transmitted by any means of communication that provides or allows for a record of its transmission. Since General Granite initiated the arbitration by sending an email, it has fulfilled its obligation with regard to this rule. Paragraph 2, Article 2 of the rules provides that delivery by electronic means such as facsimile or email may only be made to an address so designated or authorized. Since the details of the designated address is not known, but Mr. Remy Twiggins has been acting on behalf of Mighty during the course of the project, it shall be deemed that Mr. Twiggins is an authorized person. Furthermore, there were no other contract personnel from Mighty that General Granite can deal with. Therefore, General Granite again has fulfilled its obligation with regard to the notice of arbitration. Point number 5. Response to notice of arbitration. Paragraph 1, Article 4 of the rule provides within 30 days of the receipt of notice of arbitration, the respondent shall communicate to the claimant a response to notice of arbitration. However, the respondent, in this case Mighty, did not reply to the notice of, thus failed to adhere to these rules. Paragraph 3, Article 4 of the rule states that the constitution of the arbitral tribunal shall not be hindered by any controversy with regard to the respondent's failure to communicate a response to the notice of arbitration. Point number 6, designating and appointing authorities. It has been agreed by the parties under the contract that RGU Law School is the appointing authority. General Granite, as provided under the contract, has requested RGU to appoint the arbitrator since it did not receive any response from Mighty for the notice of arbitration. Point number 7, appointment of arbitrators. Paragraph 2, Article 8 of the rule provides the list of procedures that it needs to follow for the appointment of arbitrators, which include, inter alia, communicate to each of the parties a list of names for the sole arbitrator. Since RGU Law School has proceeded with the appointment of the arbitrator, it esteems the list of procedures were followed and Mighty, the respondent, was aware of the arbitral proceedings. Point number 8, stay of legal proceedings. This is regulated by Section 9 of the Arbitration Act, which is a mandatory provision. Before the court can stall or stay the proceedings raised in order to permit arbitration proceedings to take place, it must be satisfied that the dispute in question arises under an arbitration agreement. It can be said that the court must be satisfied on two matters under Section 9(1) of the Act. Number 1, that an arbitration agreement exists, and number 2, that the dispute arises under it. Section 9(1) was examined in the case of Burst Construction Limited versus St. David Limited. In reaching his decision, Judge Lloyd outlined options to determine whether it would be appropriate for the case to be stayed, which can be summarized as follows. Option 1, deciding on the issue of whether there is an arbitration agreement or not, and option 2, allowing the arbitrator to make the decision under Section 30 of the Act. For option 1, as stated earlier, while talking about the interpretation of arbitration agreement, there is a clear provision for arbitration agreement under Article 21 of the contract. As for option 2, i.e. Section 30 of the Act, this deals with the competence of the tribunal to rule on its own jurisdiction. This section states that unless otherwise agreed by the parties, the arbitral tribunal may rule on its own substantive jurisdiction as to whether there is a valid arbitration agreement, whether the tribunal is properly constituted, and what matters has been submitted to arbitration in accordance with the arbitration agreement. Therefore, the Council argues, since there is a valid arbitration agreement and Section 30 of the Act provides for the tribunal to rule on its own jurisdiction on this matter, the arbitral tribunal should continue to hear the case. The option provided by Judge Lloyd was also approved in the case of Mid-Gulf International Limited versus Group Chimichi Tunisian and Ahmad Al-Naimi versus Islamic Press Party. Now that the Council had presented the legitimacy of the arbitral tribunal continuing the case from the point of view of General Granite versus Mighty, we shall analyze the relevant provisions applicable in the Arbitration Act and UNCITRAL rules with regard to General Granite against Abacus Engineering. Point number 1, second respondent. Paragraph 5, Article 17 of the rules provides that the arbitral tribunal may, at the request of any party, allow one or more party to join the arbitration, provided that they are part of the arbitration agreement. Since Abacus Council had presented itself at the arbitration and General Granite do not object to this part of requirement is considered fulfilled. Point number 2, jurisdictional issues. It is noted that the contract between Mighty and Abacus states that it shall be governed by Scots law. Therefore, there is also jurisdictional issues arising in the arbitration. Section 31(1), which is a mandatory section of the Arbitration Act 1996, provides that an objection that the tribunal lacks substantive jurisdiction at the outset of the proceedings, which Abacus is doing by stating that the present tribunal cannot continue to hear the case at all. Section 3(4) of the Arbitration Act provides that in this instance, the tribunal may rule on the matter in an award as to the jurisdiction, or deal with the objection in its award on the merits. If the parties agrees which of these course of the tribunal should take, the tribunal shall proceed accordingly. Further, Section 31(5) of the Arbitration Act provides that the tribunal may in any case and shall, if the parties agree, stay proceedings whilst an application is made to court under Section 32. Granite do not agree to stay the proceedings and request the tribunal to continue to hear the case. In conclusion, the Council argues that General Granite has followed all the applicable laws and rules in relation to Arbitration Act 1996 and UNCITRAL rules respectively, including serving the notice of arbitration and appointment of arbitrator. Further, the Council has provided its views on why the court would permit arbitration proceedings to take place in the event of dispute, thus respectfully request the tribunal to continue to hear the case.